several times in newspaper, over media channels, and in general discussion. You have listened about different verdicts of the Supreme Court. Hello everyone, I am Sanjeev Kumar, the faculty of Yojna IAS. Today I am going to discuss about various powers of the Supreme Court. Several times in newspaper, over media channels, and in general discussion, you have listened about different verdicts of the Supreme Court. And I hope almost all people, at least the literate people, somewhere in their life have listened the word Supreme Court. So what are the powers of Supreme Court? How it is the highest court in India? What kind of powers it deals with? We are going to discuss about all such things. So powers of Supreme Court of India. Supreme Court of India has various powers. Supreme Court of India consists several powers. Some of them are as follows. Number one is original jurisdiction. Article 131. This original jurisdiction include the power to settle dispute between two or more states, between center and state, between center on one hand, two or more states on other hand, or between center, states and union territories. So any kind of dispute either between center, state and UTs all deals under the power of original jurisdiction. Why its name is original? Because it is the exclusive jurisdiction of the Supreme Court. There is no other court in India which includes such power to settle dispute between center and different states or the union territories. Now, what kind of dispute arises generally between center, states or union territories? Any matter related to finance, means sharing of finance, excluding the matters which comes under Article 280 under the power of Finance Commission. So excluding all such matters, dispute may be related to any policy issues. Suppose that dispute arise between center and Tamil Nadu government over conduction of NEET exam. Tamil Nadu government looking for certain autonomous power under the state government to held NEET exam as per its own convenience. This matter raised in Supreme Court of India, and Supreme Court of India also provided limited autonomy to the state government. Further, suppose that Bihar government come in concern with the central government with respect to a special category state. It was looking that Bihar should be granted as a special category state. Rajasthan government came in dispute with respect to reservation rights and promotion for SC, ST or weaker section of society. So such kind of disputes are very common across center and states. Further, suppose that in Karnataka and Tamil Nadu there was dispute over the water sharing. So this also raised within the Supreme Court of India. But sharing of water means Kaveri water was shared. Sharing of water if comes under exclusive authority of Water Dispute Tribunal under Article 262, then Supreme Court generally does not deal with all such matters, because all such powers are given to special water tribunals to settle the matters. But still, this Kaveri water dispute also exercised by Supreme Court of India under its original jurisdiction power. Then later on, this case was devoted to have separate water tribunals to decide how much amount of water will be shared with the Karnataka government, with the Tamil Nadu government. Similarly, over Satluj Yamuna link canal. So this Satluj Yamuna link canal was proposed after the separation of Punjab and Haryana. Haryana government already have constructed this, but Punjab government has not constructed. So this matter was raised in Supreme Court of India and it is under the dispute. Such kind of all matters associated with all such things can be raised in Supreme Court of India, and Supreme Court of India have exclusive authority. Means there is no other court, including High Court, District Court, Session Court, any other court doesn't have such authority or power to settle such dispute. Article 262, further, any matter related to finance comes under Article 282, 280, or any matter related to any treaty, covenant, agreement will not fall under the original jurisdiction. Will not fall under the original jurisdiction. So I hope this original jurisdiction is clear to you. Now we are further moving for another very important power. You have also listened or studied them within fundamental rights. Under Article 32 of Indian Constitution, there are 5 writ jurisdiction power exercised by Supreme Court of India. So Article 32 provides such authority, and with respect to High Court, it is Article 226 of Indian Constitution, which provide similar authority to exercise writ, to issue writs, to defend fundamental rights of the individual. Now what are these writs? These writs are the command, power, authority to the Supreme Court of India, which issued to defend certain fundamental rights. Suppose that number first is habeas corpus. So habeas corpus, all these writs name taken from the Latin word. Habeas corpus means to have body of. To have body of. Suppose that if any person illegally detained by authority, by the state authority, by private individual or any other organization, if confined someone, detained someone without valid authority, then Supreme Court of India can issue habeas corpus writ to release that person immediately. Such person need to be released immediately. Suppose that authorities detained Minister of Tamil Nadu, released irrespective of charge accused or imposed on him, because under the authority of jurisdiction. Further, if under the trial also charge will be proved, he will be further proceeded for the imprisonment, otherwise he will be released. So bail was given. Suppose that the person Shah Faisal, 2010 UPSC topo, he was detained by certain authority at Delhi airport. Then her wife went to Delhi High Court for issuing the habeas corpus writ, but later she withdrew. Otherwise means if you, your friend, family member, any person has been detained on behalf of him or her, you can go to the Supreme Court directly to protect detention or to ensure freedom from confinement. So this habeas corpus can be issued against government as well as private authority or any organization, it can be issued. Second one is your mandamus. Mandamus means we command. Means court can give the command especially only for government authorities, only for state authorities, for state personnel, the government servant, to follow their duty if they are not doing their legal duties, their expected duties as per their position. One of the case I can take here, suppose that municipality worker within Delhi left their job, left their work, and these workers for a very long time period demanding for rise in the wages, but Delhi government was in tussle and not agreed to raise, to hike the wages of these municipal workers. So these municipal workers go for a strike, they left the work. Then this was the monsoon time period. Within one day, garbage started to pile up, to accumulate over the street. After that, rain also happened. Now garbage is floating. Garbage is floating over the street. Some of the residents find it very awkward, unhygienic. So they move to the Supreme Court and ask the Supreme Court, please issue mandamus writs so that these municipal workers should return to their work, so that state need to remain clean. Irrespective of their differences, they can later on demand or they can follow different other methods rather than leaving their work. Then Supreme Court of India gave them order or directions or command to restore, to return back to their duty. So if any government servant is again and again not doing his duty or delaying your work, suppose that if such person is not granting you the pension, means because of arbitrary use of power, he is denying you. Otherwise, you are very well eligible, you have all valid documents, etc. Then you can go to the court that such officials, government official, is not doing his legal duty, including magistrate and different other authorities under this, means against the administrator, it can also be issued. So all government workers are subject to mandamus writ. Third one is prohibition. Prohibition. So this prohibition writ means to forbid. Here superior court forbid the inferior court if inferior court is exceeding from its jurisdiction. Suppose that inferior court do not have jurisdiction power and it is encroaching upon unaccounted power, then in such case the superior court can stop the inferior court in proceeding particular matters. Means district court, high court, All such courts have jurisdiction within their territory. Beyond their territory, they don't have. Further, they cannot deal with all kind of power. Suppose that High Court cannot settle the dispute between two or more states. It is exclusive authority of Supreme Court. Suppose that Session Court, District Court, if arbitrarily gave death sentence to particular person, accused or guilty person, then it need to be confirmed by High Court. Okay, so all such power with respect to their jurisdiction power, if it is exceeding, then superior court can issue prohibition writ. Another rate very similar to it is certiorari. The certiorari writ means to be certified or to be informed. Means superior court can ask to share the information or transfer particular case if it is delaying, if it is pending for very long time period, if lower court is exceeding its jurisdiction, does not have such power, etc. In all such matters, the superior court can ask to share the information to proceed to transfer the case to the superior court. And both these rates can be issued Both these rates can be issued against judiciary and quasi-judicial bodies. Judicial and quasi-judicial bodies. Now last one here is quo warranto. The fifth one is quo warranto. This quo warranto means by what authority? By what authority? Means the court can ask to particular government officer, especially it is issued only against the government bodies. If any person, government official holding his post beyond its eligible time period, suppose that beyond 65 years of age, or remember that VK Singh, he want to continue his office beyond his tenure based on difference in the birth certificate, based on difference in his stamped certificate related to date of birth. Suppose that if any person by utilizing the forged documents does not have eligibility criteria but holding particular post, then such person can be asked by the Supreme Court by what authority you are holding this post. By what authority you are holding this post. Okay, so means somewhere it prevent illegal usurpation of government post or offices. No person can illegally possess such offices. So second is writ jurisdiction. Hope writ jurisdiction is clear to you. If you have any query with respect to original jurisdiction, with respect to writ jurisdiction, please raise. Now further we are moving to next power, appellate jurisdiction. So So Supreme Court is the highest court of appeal. Supreme Court is highest court of appeal. There is no other court which is entertaining the appeal against the Supreme Court. Supreme Court review its own verdict, can review its own verdict if it is required. Means Supreme Court have the self-correcting mechanism. But against the verdict jurisdiction of inferior court, you can go to the help of Supreme Court. Against the verdict of High Court, you can go to the Supreme Court. Now, appeal can be made in matters related to civil. In civil matters, appeal can be made. Now, appeal can be made against the judgment of High Court. If High Court gave the verdict of acquittal, if High Court has reversed its previous verdict of acquittal, means it already awarded a person not guilty and acquit from all the guilts. It released the person and then it reversed its verdict and awarded him death sentence or 10 or more year imprisonment or death sentence. Then in such case, appeal can be made. Appeal can be made in Supreme Court of India. So first, let's suppose in any of the criminal matters, you have been awarded 10 or more year imprisonment. Any criminal matters, you have been awarded 10 or more year imprisonment. Then you can make appeal in Supreme Court against the judgment of High Court. Or if High Court certified that case is fit for Supreme Court of India, then appeal can be made in criminal matters. Criminal matters means generally in which punishment is awarded. Now let's have clarity about your civil matters. Civil matters means in which you are not awarded the punishment, rather there are very family kind of dispute, family, relatives, or related to money settlement, property settlement, etc., which are not grave crime, rather it is general misunderstanding or having differences in opinion with respect to all such non-criminal matters, means family matters or related to monetary property matters, etc. So civil matters, appeal can be made in civil matters in Supreme Court of India if any person is not satisfied with the decision of High Court, but the condition that in opinion of High Court the matter should be dealt with certain matter related to urgent public importance. Urgent public importance, or if there is significant matter which require interpretation of law, then appeal can be made in Supreme Court of India. Number 2 here, if High Court certified if High Court certified that case is fit for Supreme Court of India for raising the appeal, or in opinion of High Court, if case should be settled, need to be settled by Supreme Court of India, then appeal can be made in Supreme Court. Now, appeal in constitutional matter. Appeal in constitutional matters means you can also make appeal in constitutional matters. Constitutional matters means case require interpretation of particular law which need to be interpreted by Supreme Court of India. Which need to be interpreted by Supreme Court of India. Appeal in constitutional matters can be made. Suppose that with respect to Delhi, whether it is a state or whether union territory, High Court of Delhi gave verdict in favor of Delhi government. Means it make Delhi government near about synonymous with the authority of different other state government. But when appeal was made in Supreme Court of India, then Supreme Court of India held that Delhi is first union territory and then later it is a state. Officially, Lieutenant Governor is the administrative head of Delhi, but he should follow the directions as given by elected government or Council of Ministers. But ultimately, in certain matters, the Supreme Court of India held that Lieutenant Governor has exclusive authority regarding this. So, if any matters related to constitution which require interpretation of law, which require settlement of some constitutional matters, then appeal can be made in constitutional matters. Now, appeal by special leave. Appeal by special leave. So, in case of appeal by special leave, this Article 136 provides such authority to Supreme Court of India. Appeal related to civil, criminal, constitutional or any other matter. Or any other matters, appeal can be made in Supreme Court of India. But it depends on Supreme Court of India. It is autonomous power authority of Supreme Court of India whether to entertain or not to entertain. Means different other rights as mentioned within matters appeal in civil matters, criminal matters, similarly are not defined here. Appeal by special leave means Supreme Court of India have a special leave by leaving all its work, the usual work, it can entertain particular kind of appeal. Suppose that in one of the case, Nitish Kumar, Bihar government, when declared, consumption of this drink as illegal, or it declared the state of Bihar as dry state. Sale and purchase of liquor, it declared as illegal, then it was obvious that lot of people who were manufacturing, blending, selling this liquor lost their employment, livelihood. So they went to the High Court, Patna High Court, that without giving enough compensation or without giving adequate time to shift from liquor, blending, manufacturing to some another work, all of a sudden, in arbitrary manner, Bihar government has declared the state as the dry state. Then Patna High Court gave verdict in favor of these liquor professionals, liquor manufacturer, blender or sailors. Then Nitish government went to the Supreme Court and defended its case, held that as per directive principle of state policy, Gandhian principle, prohibition of consumption of intoxicating drink, a state government has banned it, so it is the very much legal duty of a state government. Further, it is causing huge domestic violence in the state government, so we have put ban, we have declared. Similarly, Gujarat also declared, so we are not the pioneer state in that matter. Means the state government is following the constitutional provision, or it is one of the directive principle, it is the duty to implement all such principles. Then Supreme Court gave verdict in favor of Bihar government or Nitish government and held that to implement all such provisions, Bihar government to maintain law and order, to curb domestic violence and to curb over illicit trade of this liquor, it can have authority to declare, to impose ban, to declare it illegal and impose ban over it. So appeal by special leave. Now there are also several other powers of Supreme Court, just like advisory power. So Supreme Court can give advice to President of India, especially on two conditions. President of India can seek the advice related to matters of general public importance, matters related to general public importance, or any matter related to pre-constitutional treaty, agreement, covenant, etc. Then in first matter, if any matter related to urgent public importance, President of India can seek the opinion of Supreme Court and Supreme Court may give or may not give its opinion. Consider after 2002 Godhra riots, this state government in Gujarat was looking for conducting the election to seek polarization of voters, to form again government in the state. So generally, after dissolution of assembly in the state government used to declare or announce the time period on which or around it the election need to be conducted. Then National Election Commission of India denying to conduct the elections. It was saying, defending that the environment is not very conductive in nature, it is not very peaceful, it will lead to polarization of voters and it will highly influence the conduction of voting. Further, free and fair elections, which is the main objective of Election Commission of India, may not be secured. Then who has authority finally, whether it is a state government or election commission, to conduct, to declare the time period on which election need to be held? So President of India seek the advice because state government also send such recommendation to central government that election need to be conducted immediately. We cannot left a state without government under the president rule. So Supreme Court of India held that it is Election Commission of India which is the final authority to decide when conduct should be held, to announce its date and to measure the environment, the conditions, whether it is progressive to conduct the election or not. Similarly, suppose that against coal scam, after this coal scam, President Mukherjee also asked to Supreme Court, seek the advice of Supreme Court, is there mandatory to have open public bidding in allocation of coal mine and allocation of natural resources. Why it can't be held at first come first service? Then Supreme Court held that generally it should be preferred that allocation of coal or different other natural resources should be based on open public bidding. It is in the interest of nation. But in certain rare circumstances or cases, government can also have right to allocate natural resources or coal mine based on first come first serve. So whenever president found himself under dilemma related to constitutional matters, legal matters, then Supreme Court is the apex authority. No one can better interpret the conditions, can give the directions or decisions. So that's why President of India can seek advice, but Supreme Court here is free whether to give advice or not to give advice. But in second of the case here, related to pre-constitutional treaty, means before formation of constitution, if there is any law, treaty, covenant existed on such matter, Supreme Court of India is bound to give his advice. But in both the cases, President is not bound. Here, President is not bound to follow the directions, the advice of Supreme Court. So advisory jurisdiction. Now court of record. Court of record means all the verdict of Supreme Court of India get recorded, and they can be quoted in similar cases in inferior court or in any other court within territory of India as the evidence. Suppose that if Supreme Court of India have declared adultery as the legal, LGBT community rights is legal, or Supreme Court of India have declared suppose triple talaq as illegal, then all the court need to follow the verdict, and lawyers while proceeding their cases can also quote the verdict in similar cases. So all the verdict of court are recorded. So it is also authority of the Supreme Court of India. Further, Supreme Court of India can have jurisdiction related to contempt of court. Related to contempt of court. So in contempt of court means even parliament cannot criticize the verdict of judges except when there are certain reasonable criticism, or except when there is impeachment motion going on. Means for removal of judge, a motion is going on, then Parliament can criticize, media cannot criticize, individual cannot criticize, although fair criticism up to very limited extent are acceptable by the court, but court has ultimate power to decide what is contempt of court or what is not. So it is all paradise of lawyers or the court. What does mean by contempt of court? So court can award you punishment, imprisonment, or both together. Means monetary punishment or fine or the imprisonment. So that is contempt of court, power of contempt of court. Further, Supreme Court have several powers related to election of president, vice president. If any dispute arises, then it is the exclusive authority of Supreme Court of India to decide such matter, to appoint its staff member, and to main rule regulation with respect to its own work. There are several such powers which is enjoyed or held by Supreme Court of India. So I hope you have all the clarity with respect to certain basic powers of the Supreme Court of India Here I am ending the discussion. Further, we will continue our discussion with respect to different our left provisions related to judiciary. Thank you very much. Bye bye. Take care.